Should federal judges who are presidential appointees simply interpret the Constitution, or should they be activists, writing law by court decree? Who are the forces promoting candidates for presidential appointments for judges and U.S. attorneys? And do large conglomerate law firms have too much influence on government decision makers? Stay tuned for an Full disclosure interviewed Attorney General Ed Meese at the Hoover Institute in May of 2005 on the U.S. justice system. In his memoirs, he mentioned that President Reagan never believed in a litmus test for his judicial appointees.
The judges that Ronald Reagan appointed have for the most part, been faithful to the Constitution, which was the only test that he required. He never had a litmus test on how they would rule on a particular subject, because no potential judge could answer that question properly, because they wouldn't know about what the facts were of a particular case. That's why it's been unfortunate lately that some in the Senate, in the minority, have asked for a litmus test and grilled potential judges on the basis of a litmus test. Ronald Reagan never did. But what he did do was try to appoint judges who would be faithful to the Constitution and understand their limited role, which was to interpret the law, not to make the law. That has been expanded over the years by the courts, so that now they're actually performing legislative functions sometimes by, instead of interpreting the law and interpreting the Constitution, they're actually trying to make law. They start with the Constitution, but then they go beyond that and substitute their personal preferences or their policy ideas and their policy biases for what the Constitution actually said. And then in the last 50 years or so, they have gotten in the business of supervising state prisons, school boards, mental institutions, and performing executive functions for which they are particularly not well fitted. They have no particular expertise, and as a result, we've had a great deal of confusion about who's responsible for the running of both state and local functions because of the improper interference by the courts. I also think that when the people of the state, by their own action in an initiative, have rendered their judgment on a particular subject, that no single federal judge, should be able to invalidate that act of the people. I think that we ought to change the rules, and Congress could do this, to require at the minimum a 3-judge panel of district court judges to look at it, so that there would be more than one judge ruling when you had something that was a popular initiative, because in a democracy or a democratic republic as we have, the voice of the people should normally prevail unless there is a clear-cut violation of the Constitution. One thing that has happened, however, in recent years is that rather than individual lawyers, we now have law firms that are made up of almost huge conglomerates. Many times we now have law firms that are literally hundreds of lawyers grouped together. And so it may be that in some cases some law firms have a disproportionate impact on what goes on simply because of their size and therefore their power. And I think that's something that has to be looked at carefully. We have a serious problem with people entering this country illegally. The estimate is that there's somewhere between 11 and 20 million people currently in the country illegally. And I think that we need to take a much more aggressive stance to prevent more people coming in illegally, and frankly to deport and get rid of those who are here improperly, and also for those who are facilitating people coming in illegally, such as those providing false documents. We particularly need to go ahead with prosecutions of those people who are making it possible for others to come into the country illegally.
Copies of our full 30-minute programs are available on DVD, videotapes, audio cassette, or transcripts for purchase on our website.